Good evening. It's Tuesday night, 8 o'clock, and this is the Bob Leonard Show. We'll be with you for about an hour. And like we tell you every week, we take the stories you've been watching on television and reading about in the newspaper over the past week, and we go behind those stories to try to tell you what's really going on. We give you the story behind the stories, or some people say we read between the lines. But we tell you every week the same thing. It's only our opinion, and you can accept or reject it. We just look at them. We say what they really mean in our mind, and again, we'll have our say no matter what. But anyway, this program will be repeated. It used to be repeated on Friday night from 8:30 to 9:30. It's not repeated there anymore. It's repeated at 11 to 12 on Wednesday night. And nothing we can do about that, but if you miss it on Tuesday night, you can see it on Wednesday night from 11 to 12. Or you can go to flinttalk.com, flinttalk.com, and it's played, I think, 24 hours a day there. It just keeps being repeated. So if you have a computer, go on your internet, flinttalk.com, and you can pick the program up there. But anyway, we have a number of things we want to talk about tonight, and there's a couple of events that are really kind of screwy. You know, if you're interested in legal matters and politics, these actions that I'm going to talk about tonight might boggle your mind. One is the kind of defiant, thumb-in-your-nose attitude of arrogant politicians to the mandate of the voters that they sent to these officials in a most recent city election in the city of Burton. What happens here is almost like a non-violent overthrow of a democratic elected government in the city of Burton. And we'll talk to you about that, how that's happening and why it's happening and who's behind it. Another story that tests the constitutional concept of federalism, which says each state is equal in influence and power, and their individual states' laws dictate to their own people what is permissible and what is not. In other words, one state cannot take legal or legislative action that imposes laws or rulings that can be imposed on how citizens of another state must act within their own state. Apparently, that's what a court ruling in the state of Georgia is attempting to do in Michigan, in my opinion. This recent court decision has been formulated to try to usurp Michigan rights to prosecute a sex offender who entered Michigan with a criminal sexual record without registering as a sex offender, as the law requires in Michigan. Now, we'll discuss how they are attempting to do this, how these states and these lawyers involved are attempting to do this. The question we have here is, will the local officials be intimidated into permitting Georgia to impose their will on Michigan citizens? Or is there really a legal defect here now that the state of Georgia acted? And is the problem that is being created here create another problem in regard to a person who may be classified a pedophile? Have they cleaned up his record so no one will know about it? Is that good? Well, anyway, we'll talk about that. We'll also tell you about the illegal actions certain elected officials in the county are engaging in that are intended to circumvent the Michigan Open Meetings Act which was really enacted to keep government open to citizens' scrutiny so that the public will know what the decisions officials are making and what they base their decisions on, who may be influencing them. We have a right to know those things. And, you know, we got to take a look at this craziness here that's going on in the city of Clio. You know, we got recall petitions on some city council people, and then recalls on those people who are trying to recall the city council. In fact, there's 5 recall petitions going around now out in Clio for the 7 councilmen or council people. Anyway, it all stems from the battle going on against the mayor who supports the city manager by the name of Mr. Yost. And Tom Yost, he's the city manager. And what happened, what they claim why they want to get rid of him, which I think is just a pretext because it's so insignificant, it seems to me, it could be straightened out without all these recalls. But what the opponents of Yost and the mayor are saying, look, the guy has an apartment downtown, he builds a stairwell or a stairway up to the upstairs apartment, and he built it on city property. Now Yost says, look, I'll buy the property, but my survey showed that the property that the staircase was built on belonged to me and the apartment that my wife and I own. Well, you know, if it's an honest mistake, you see, it seems to me it could be worked out. Because the property that the city's talking about can't be used by the city. That's the opinion of most experts that have talked about it. This is just a hassle. This is just a vehicle, in my opinion, they're using to get rid of this guy, Yost. I don't know how good he is, but it's ridiculous. They're going to have 5 names of the 7 council people on the ballot in May for recall. Well, you know, what's going on in Clio? Well, we'll be watching that, but it seems to me to be something about nothing, and it just has to do with politics as usual. And they've resorted to something that should be a last resort, and that is recalling people who are elected. You know, you try to work it out beforehand. You try to compromise. You try to meet and get the things straightened around. But apparently these people are so antagonistic towards each other. Maybe they all should be recalled and new people put in. Maybe you'd have a better chance of getting things done in Clio. But this is crazy, and using this pretense to justify the action here. Well, let's go on. We also want to talk to you about the latest thing that's happened in Argentine with the cop that was suspended for something a woman says he made her do, and we have an update on that, and I'll get more detail of that. But let's talk about what's going on in another city in Genesee County, which is a little crazy. You know, who would have ever thought in this day and age that you would see in America the hijacking of a duly elected government by a minority of malcontents? But, you know, that's what's exactly happened in the takeover by a group that wants to resurrect the influence and power of their friend, Mayor Charles Smiley, by putting 2 of Smiley's lackeys into 2 recently vacated council positions in the Burton City, on the Burton City Council. You know, this convoluted action taken by this minority of the council people demonstrates the Smiley people's unconcern for really a mandate that came from the Burton voters in 2005 when they, in effect, demanded change from the arbitrary and arrogant dictates by Smiley and his administration. They wanted I'm convinced by this vote, and I'll get into the vote in just a moment, they wanted a more even-handed approach to governing the city, in my opinion, and I think the opinion of most of the people who voted. You know, despite this mandate that I'm talking about, a fellow by the name of Gary Isham, who is the councilman, one of the councilman's friends out there from the city of Burton, and Smiley's architect in this kind of overthrow. And they started by putting a fellow by the name of Jeff Majors, who was an employee of Smiley for 16 years until he recently retired. They put him in one of the positions. Now, up until that time, the independents, or some refer to them as kind of anti-Smiley people, had a 4-3 plurality on the 7-person commission, or council. And that 4-3 came to be because of the elections in 2005, where the Smiley people who were running for those positions lost, and the so-called anti-Smiley people were elected. Now, what happens is an opening occurs, and they put a Smiley person in that position. That was vacated by somebody apparently who moved out of the community. Now we have another opening to fill. In this particular case, they want to fill it with a fellow by the name of Ralph LeDuc. LeDuc was Smiley's public works director for years and years and years, and owes him a great deal. The choice of LeDuc would switch the, if it occurred, would switch the control of the council back to Smiley, where they would just rubber stamp everything he wants. There'd be no watchdog over that council, or over that mayor again, and we'd be back into the same situation that we were before. Taking care of his friends and giving large donations to his appointed employees, like LeDuc. You know, just to give you an example, LeDuc, and I think you remember this, we talked about it before, was such a good friend of Smiley when he gave him Smiley gave him $10,000 bonus a week before he retired. And he had already given him a $10,000 bonus at the beginning of the year, so he got an extra $20,000 in his pocket. But equally important, it raised his pension payouts, because the pension is also determined on the bonuses. It raised the pension payout about $800 a month for LeDuc. Man, he owes a lot to Smiley. And then Smiley helps him get a new job when he retires. He's getting a pension probably around $60,000 a year, and he gets a new job over there at Atherton School as the athletic director, which Smiley helped him get through his friends on the board over there. He gets another $60,000, $70,000 a year. So here's a guy making $120,000, $125,000 a year that's retired, and Smiley helped him get all this pension and these jobs and everything, extra jobs, new jobs. So he has a commitment to him. You know, and remember this. I'll show you his attitude, LeDuc's. Remember, the pensions here are not contributed to by Smiley or his people, his administrators whom he appointed. It's paid for totally by the taxpayers. And, you know, do you remember the story I told you that, you know, it's not a story that happened. LeDuc also charged the city of Burton on their credit card to fix up his house. And then he refused to reimburse the city for the cost of fixing up his house with their credit card. Now, that was true until somebody working at City Hall was so outraged by it, they became a whistleblower and sent the evidence of the LeDuc's misappropriation of these funds to the press. And the press came down on the issue and he finally paid it. Now, this is the guy they want to appoint to the city council. Now, there's a lot of facts that support this position that the majority government voted in by the voters in the 2005 council election really has been emasculated by Isham and his friends who are pro-Smiley people. You know, some people say, well, maybe they didn't get the message. They got the message. They got the message that people want to change. That's why they elected the people they did. They don't care. That's been their attitude for 16 years while Smiley's been mayor down there. You know, putting Jeff Majors into one of the openings on the council, you know, the result is that the council's now has 2 blocks, 3 council people each, and then they have the one council position that's open that they want to fill with LeDuc. You know, before the 4th position has been filled by LeDuc, and I'll get into that. He really hasn't filled it, but that's who they want to fill it with. You know, it was, as I say, 4-3 for the independents or the anti-Smiley people. They were all elected by the voters. Now, if the Smiley group takes over 4-2, 2 of the people have been elected by the voters, and 2 have been appointed by Smiley and his people. You know, remember this. In 2005, LeDuc ran. And he came in second to last. He was soundly defeated by the voters. Now, they want to take and appoint this guy, who the voters rejected just a year ago, and shove it down their throat. Now, here's the situation here. They call a special meeting, Isham does, to fill the vacancy, the 7th position, with LeDuc. And this was 3-4 weeks ago. Well, what happens is, when they get there, there are only 5 people, 2 against the appointment, and 3 for the appointment of LeDuc. But it's a special meeting, and the charter requires that in order for the issue to prevail, here the appointment of LeDuc, you have to have 4 votes. So they only had 3, but they still appointed LeDuc. Now, the city attorney makes an interesting observation here. And keep in mind, this is he was assistant city attorney for Smiley and his friends for about 11 years before they appointed him city attorney. he comes out with this crazy decision. He says this in the paper, and this is the Journal article of January 17th. It says, efforts failed to boot Burton councilman. The city council rebuffed 2 attempts Thursday by a faction of council members to undo the appointment of Ralph LeDuc. LeDuc was appointed to the council by a 3-2 vote January 4th, but city attorney Richard Austin said the vote was invalid because 4 votes were needed to appoint the former city public works director. Now listen to this when I talk about convoluted thinking. But Austin has also said that since LeDuc was sworn in, he can remain on the city council unless a court rules otherwise. Well, I thought that was his job, to give them direction. And it says LeDuc is serving the remaining 10 months of a Jamie Curtis term after Curtis left to become Genesee County Commissioner. Now here's another issue that developed here. Council member Lori Tennant and Charlie Cross, who make up the 2 of the anti-Cross people, led attempts to oust LeDuc, including a special meeting on Tuesday called by Tennant asking for another vote on the appointment. Austin told the council that since LeDuc was sworn in, there is no vacancy on the council and no basis for the vote. The special council meeting was adjourned without a vote. Later Tuesday, during the regular council meeting, Cross asked for a vote to send LeDuc's appointment to the Michigan Attorney General's office for review. Now, they were going to try, and that is Isham and his people were going to try to put LeDuc in at not the special meeting now, but the regular meeting, where they said we only needed 3 votes to do it. But what happened was they didn't expect Charles Cross, the councilman from Burton, to show up because he'd been ill, but he went, and all they had was 3-3. They couldn't put him in. So they just didn't take the vote because they know they'd lose it. But now Lori Tennant and the anti-Smiley group say, well, listen, this is ridiculous. You say we can't appoint him with 3, but you say since he's sworn in, he can serve. That's crazy. Absolute crazy. So she suggests, and Cross and I guess this Conley woman who's also with Cross and Tennant, she goes, well, wait a minute. Let's ask the Attorney General for an opinion. They make the motion. They have 3 votes for it and 4 against. Guess who cast the deciding vote? Mr. LeDuc. Now, this is crazy. LeDuc, it's on the issue of whether he can serve and whether he's serving properly at all. He cast the 4th vote. And clearly, according to Austin, his appointment was invalid because he needed 4 votes to get elected. But since the clerk, who was a Smiley appointment, swore him in, he says now he can serve and vote, and he can be on the council, even though he didn't get the votes needed to do so according to the charter. So now you got this crazy situation going here. And if LeDuc claimed he had a right to vote, shouldn't he have disqualified himself because he was obviously prejudiced? He cast a vote that would prohibit it from going to the council to see if he is properly sitting on the board or on the council. You know, one saving grace on this whole debacle is that next November, these 3 Smiley people will be up for election. If the voters speak clearly and get rid of the smiley people, maybe, just maybe, we'll see the city being run again for the benefit of the people of Burton. We'll have to watch and see that. But anyway, I want to show you the tape on this. Can you run that tape for me, please?
Ralph LeDuc will keep his position for now. Earlier this month, the Burton City Attorney said the appointment of Councilmember Ralph LeDuc was invalid because the council didn't have the 4 votes needed to approve the appointment. LeDuc was appointed to the council during a special meeting session in a vote of 3-2. Last night, another meeting was held so members could vote once again. The meeting was adjourned without a vote taken.
See, that was the fact that Cross showed up when it was 3-3, and they couldn't have put LeDuc in by the 3-2 vote because they didn't expect Cross to be there, but he was there, so they didn't take the vote, which is, you know, kind of undemocratic. You would think you want all the people that were elected by the people to participate in any activity by the government, but these anti-smiley people, they just want the power back, and that's what this is all about. But anyway, we'll keep an eye on this for you, and we'll see where we go from here. We just learned that the Argentine police chief, Terry Van Kersen, something like that, has finished his investigation on the police officer from his department that had been accused of asking a female passenger in a car he stopped for a traffic offense to show him a couple of reasons why he should not ticket them. And then when he checked his the radio, he found out there was a warrant from Shiawassee County to arrest the driver, who was her cousin or her nephew or something like that. Well, she showed him, pulled up her blouse or whatever, her sweater, and showed him her breast, and he says, okay, go ahead. And he didn't arrest him, and he didn't ticket him. And the police chiefs suspended him while he did an investigation. And since that time, the Argentine politicians on the township board out there are demanding the chief put this cop back to work because he has some political influence out there, and they want to do that. Here's a report that we've shown you, but to update you on it, can you play that again, please?
Katie O'Mara, tonight the revealing details about an investigation that has left one officer suspended and a small town questioning whether a crime was committed. TV5's Lori Jane Gliha live in our newsroom with more. Lori Jane.
Katie, this all comes down to whether a police officer actually did something wrong and how the township board and how the police chief are investigating it. A traffic stop several months ago in Argentine Township seems to have sparked a bit of friction between the police chief and the township board.
I wish that they could pull together to accomplish more.
The ongoing feud is nothing new, says Holly Gall. She's lived in the township for 20 years, and this time the friction started when a woman accused an officer of allowing her to show her breasts to him. In exchange, he'd let her friend, facing a misdemeanor warrant, get off the hook. The alleged incident led the chief to investigate the officer, and when the officer tried to resign, the township board refused to accept it. Instead, they voted to put him on administrative leave. TV5 could not reach the chief tonight, but his attorney tells us the chief wanted to pursue the investigation a little bit further. As a result, he felt the board targeted him and started harassing him by, quote, micromanaging everything he did. That's when the chief filed a lawsuit against the board.
I wish that everything could work cohesively.
A few township residents say they've been in the dark about all the intricacies of the turmoil, but watching the government at odds is frustrating. Some wonder whether it will ever go away.
Personal agendas should always be put aside for the good of the community.
And tonight I left several messages for the township supervisor, but I have not heard back from him yet. I also was not able to get a hold of any of the other township board members or the trustees. Live in the Genesee County newsroom, Lori Jane Gliha, WNM TV5 News on Fox 66.
All right, Lori Jane, thank you. The officer who tried to resign.
The update on that is that the police chief has now finished his investigation. He has refused to put the cop back on the road because of these allegations. Now that he's finished his investigation, apparently he believes the woman and the driver of the car that she was asked to show her breasts, and as a result, he doesn't think he should go back on the road, and he should be fired. Anyway, he says, look, I've got 2 sworn statements from the woman and the driver of the car that he was let go, there was no ticket given, and he wasn't arrested on the warrant they had for him. It was a misdemeanor warrant. And that they swore to those things under oath, and that when he asked the defendant or the cop about it, the cop took the Fifth Amendment. So the chief says, as far as I know, the people are telling the truth, and therefore he shouldn't go back on the road. Now, I would suspect that they probably, the cop, I think the chief is right. He's trying to do a good job. He's not letting politics interfere in his decision making. And so he's probably a good chief, but because of the politics out there, he may get fired over it. And that's too bad. It's interesting to think about what the public out there might do. Well, anyway, let's go on here. I told you at the beginning there's kind of a new wrinkle in the Julius Anthony case that we anticipated was coming when we mentioned it last week on this program. Anthony is the former Flint School District Administrator who was charged recently here in Michigan for not registering as a sex offender, the results of a guilty plea for a sexual assault case on a 3-year-old child. You remember that? It was in the Journal. Anthony abused boy 3 in 1996. And that wasn't on his application or anything. He was given a job here in Flint as, a top administrative position on curriculum and instructions. And he was a friend of the superintendent, and that's one of the reasons he got the job. Now, since that time, now he's been with the Flint School District a little over a year, both as a contract employee and then as an employee itself. And the Sexual Registration Act applies to both situations, whether you're a contract employee or what have you. You have to disclose it. And there's a state law that requires that it be disclosed. And not only disclosed, but there's a state law that requires that the persons be fingerprinted and a record check be made of them if they're going to work in the schools, whether you're a custodian or a superintendent. And they couldn't get the superintendent or Anthony to agree to fingerprinting until the teachers union filed a Freedom of Information request to see what the fingerprints showed up on these guys, and they had never been fingerprinted. And they had been advised to do it for months and months, and they just ignored it. Now, obviously, if he is fingerprinted, that is Anthony, this conviction would show up. So there was obviously some reason why he didn't want to be fingerprinted. Now, as I understand the Georgia judge ruling, according to the Journal, he didn't rule on the facts of the case, that is, whether they were true or false, but decided the case on a technicality. Whatever the ruling in Georgia, the fact remains that when Anthony arrived in Michigan in 2005 and began working with the Flint School District, he had a criminal sexual conviction that Michigan law required him to register for. Now, according to the Journal, the conviction was set aside last Thursday by this Georgia judge. Consequently, regarding the Flint accusation, and when it was made, he was in Michigan for failure to register as a sex offender in August 2005 when he had the record. Now, the fact that it was dismissed in Florida, I don't know how it can be retroactively applied to a year ago in Michigan, when you're talking about a Michigan law as distinguished from Georgia law. You know, what's really disturbing about the recent development in this case is the lawyers for Anthony are trying to impose the Georgia court's ruling on Michigan interpretation of our own laws. Now, if this dismissal, which consummated this past Thursday, is good, then, in my opinion, Anthony was a registered sex offender. Should have been a registered sex offender, but they might make it retroactive, and I don't know how the prosecutor is going to handle that. I just think that the violation occurred. And I don't think the Georgia ruling makes Anthony any less a sex offender as far as registration was concerned, because he was here when he came here, he had the record. And keep in mind, as far as I know, there has been no determination, and it's hard to get the information out of Georgia, and we're still trying to do that. But it would appear that the case was dismissed on a technicality, which their attorneys claim he didn't sign the agreement to plead guilty to the misdemeanor, that is, Anthony didn't. Apparently they have a rule down there that if the attorney, it's a misdemeanor, he can sign it. I mean, that's the only thing I can figure out. And now they're saying, well, Anthony didn't really know that he was convicted, and therefore when he came to Michigan, he didn't have to register because he has no knowledge of it. But let me tell you, you know, what I'm concerned about is that here we have a guy, based on the facts, not just only his plea of guilty that he's now withdrawn. We have a guy that's really a pedophile, you know. Anthony abused a boy 3 years old. I mean, that's pretty bad. Now, there are other evidence and circumstances that suggest to me that Anthony is a sexual offender. First, keep in mind he did plead guilty. Now it's set aside. Claims he didn't sign the plea, but whatever. The plea was entered, and if an attorney can do that on behalf of his client, he has to communicate to his client. Now, did they think that he did this without communicating it to Anthony? This is ridiculous. You know, when Anthony's attorney made the deal to plead to the lesser sex crime of a 3-year-old, it doesn't make a difference. He was required to register in Michigan. Keep in mind that the prosecutor's file in Atlanta says Anthony pleaded guilty to the lesser charge. Now, since that time, you know, there's been a lot of jockeying down there in Atlanta. No telling what the file might say now. But he pleaded guilty. Now, keep in mind, too, here's another reason I think that there's more to this than meets the eye. You know, Anthony flunked the lie detector test on the issue of his alleged assault in this case. He flunked it. And then, keep in mind, when he was confronted by the allegations here in Flint, he never said, hey, I didn't know I had this conviction. He didn't deny the conviction. He just got out of town in the cover of darkness. You remember that tape, that video that Channel 20 or 66 did? Right? He was leaving town one night, and they wouldn't talk to him, and he was getting out of town fast because Layton had given him the option of filing as a sexual offender under Michigan law, and he had to do it within 10 days. Well, he got out of town before the 10 days. And keep in mind, I think he's a confirmed liar when you look at his application. He claimed he had no conviction. Did he think maybe the conviction or the prosecution, the felony he was charged with, just dissolved in the midair? No, he knows he pleaded guilty to the misdemeanor, which was a sexual offense. And he claimed he had no conviction in his application. He lied about that. Then he lies about having a master's degree, which was a requirement for this position. He never got a master's degree, or didn't have one at that time he made the application. I don't think he has one yet. And then the requirements for this job require that he have a number of years of teaching elementary education. He taught, according to the St. Louis Post-Dispatch, he taught as a substitute a few times. So he lied about all his experience. You know, maybe these people hollering loudest about Anthony's state prosecution here for failing to register might want to go back to the Flint school system and demand Anthony be given his job back, and then see how many parents would agree with you on that, would like to have that guy back in the school system. There was an interesting story on CNN today. Not CNN, ESPN, no, CNN. And it brought to mind what was happening here. I want you to...
Sounds like a stellar student, but a shocker for parents that a 29-year-old was posing as a 7th grader. How the sex offender fooled everyone for 6 weeks.
In the neighborhood, he passed himself off as a 12-year-old boy to get into a middle school. As Christopher Sign of Phoenix affiliate KNXV reports, it may be the first time he conned his way into a classroom.
He just blended in.
29-year-old Neil Roderick fooled many, posing as 12-year-old Casey Price. The convicted sex offender spends 6 weeks sitting side by side with unsuspecting children and adults.
I was incredibly surprised. I don't understand how a 29-year-old male can be misunderstood as a 7th grader.
Parents picking up their children at Rosefield, a surprise charter school, receive a letter informing them of the 7th grade imposter.
He was here for 50 days?
Yeah, 7th grade.
Very shocking. I'll have to definitely talk to somebody about that.
School administrators and police investigators have many questions and few answers. Counselors are working to determine if any students were victimized by the sex offender, who some called a good student.
He was a quiet student. He turned in his homework. There were no administrative or discipline issues.
And this isn't the first time the 29-year-old got inside the classroom. He was registered in Payson, in Prescott Valley, and busted at a Chino Valley school.
Like the other schools involved, he provided falsified documentation.
Some parents fear what they'll hear when they ask their children about 12-year-old Casey Price. In Surprise, Arizona, Christopher Sign, CNN.
Now, I show you this because I make the points that I've made, and I wanted to show you this clip. I thought it was kind of interesting that it showed up at about the same time on this Anthony. The fact of the matter is, this guy comes into this school district with this problem that he has, obviously, sexual problem. And the school board does nothing about checking him. Never demanded that he be fingerprinted and his record checked before they hire him. And then this is what happens. You get someone like this in the school, just like in this particular case on CNN. You don't know, these kind of people go wherever they have kids. Yeah, I make the points because I truly believe that Anthony has a serious sexual problem with youngsters. And he's menacing to any child, wherever they live. This could happen any place, just like in this school thing. These guys hide who they are. Here come Anthony into a school district with young kids. You know, wherever he lives, wherever children live, or wherever he goes, we got to be careful with him. That's what happened in the career case. The school board did nothing and hid the fact that he was assaulting underage girls, 12, 11, 13 years old at Whittier School. And he went to Florida and did the same thing for the next 10 years, causing one girl to commit suicide. Now, we got this situation here. We're covering up a serious problem and just passing it on to someone else. And you know, we shouldn't be conned into giving this guy Anthony some kind of hero status because he beat the system. Now, Layton's got a tough decision to make. Whether he will go forward with this case, because when Anthony came here, he did have a record and he was required to register under state law. And whether it's the decision in Georgia can be made retroactive to take that responsibility from registering away from him, make it unnecessary. But again, you have to look at what the court decided and how they decided it. But the fact of the matter is, these things did happen. And he was in our school district. And you saw how far these people would go to get next to these kids, like this 29-year-old man. And again, the woman saying, how did this happen without us getting information on it if it happened in other areas? And that's what we're doing in a case like this, in my opinion. We're moving this problem to someplace else. If we've got a shot and we can take it legally, we ought to take it. But if we don't, then it just moves on to the next area, the next place, and it stays with whomever is exposed to it. You know, it's a tough call for Layton. We'll watch and see, and we'll keep you informed of what's going on. But at least he's out of our district, and he becomes someone else's problem, unfortunately, if nothing is done in regard to the criminal prosecution here. And as I say, maybe legally you can't do anything. But I'm sure Layton will look at it and see what happens. You know, there's an interesting story here on called the Genesee County Commissioners will then close meetings. See, there's a law in the state of Michigan called the Open Meetings Act, which requires decision makers like politicians and elected officials and appointed officials to meet, if they meet with a quorum of an organization which has a quorum like a city council or a city commission, they must give notice to the public the meeting is being held, because they can make decisions with a quorum. So what they do is they try to trick you by holding meetings with less than a quorum and then passing on the information, or meeting with smaller and smaller groups, but when you total it, it is a total group. For example, here they have a meeting with 4 people. It's a 9-member board, you need 5. So they discuss the issues. They get rid of all of the problems and all of the embarrassing things that might come up if it was a public meeting concerning supporters of the commissioners who may be coming before the commission for certain actions. They get all that out of the way. You walk into a public meeting, and there might be a few minutes of discussion. nothing serious, and then they take the vote. The vote's already predetermined. And that's the whole reason, the Open Meetings Act, because the public is shut out of the decision-making. So Ron Fonger, who is the fine reporter for the Flint Journal, who we mentioned many times here, caught them at it. And he says, members of the County Board of Commissioners will stop leadership meetings held behind closed doors, ending a long-standing practice that shut the public out of discussions on sometimes controversial subjects. Commissioners have said there was nothing nefarious about the leadership meetings, which involve 4 or fewer commissioners, less than a quorum. You know, it's surprising that they never would have the quorum, because they obviously didn't want the public to hear what they were saying. I don't think they necessarily did anything wrong, but decisions were being made which the public has a right to participate in, and they weren't allowed to participate. And it says no votes were taken by the group, which had rotating makeups depending on invitations by the board. But you can bet, this is what they call round robin. This is illegal. Michigan's Court of Appeals, Michigan Supreme Court says you cannot do by indirection something you're not, or by indirection something you can't do by direction. And if you have a meeting in which a quorum is there, you have to give notice, and you have to put it in the paper, and you have to have the public invited. But if you can have 4, and then they make all the decisions, and they discuss things back and forth with other commissioners, then when they go to the meeting of 4, they decide what they're going to do. They go out and tell the other commissioners who have agreed in advance, and they go on the floor, and the public sees it, finally shows up at the meeting, and it's all fixed. It's already fixed. City Council, Flint City Council is doing that now on certain issues. Meeting with, instead of meeting with 5 people, they meet with 3, 3, and 3. All 9 of them will be briefed by whomever. And they say, well, we didn't have a quorum, it's all right. That's round robining. That's, the courts have said that's violation of the Open Meetings Act. Ron Fonger came up with that story and exposed that in the City Council. It's been going on a number of years, and thank you, Ron Fonger, for it. But it's happening in the city of Flint, too, and it's going to blow up over there, too. But they don't want the public involved, you see. They don't want to be discussing things that they don't know what the answer is to. They get the answer before they go in there. And you don't know what's behind all of this action because you haven't heard the discussions. Just this last night, there was a Truancy Act up for consideration and a curfew law up for an ordinance in the city of Flint. And the sponsor of this was a fellow by the name of Neely, who is, I think, the 6th Ward councilman for the city of Flint. And this was his great claim to fame. He wanted this curfew law, and he wanted this truancy law. Well, he knocked himself out to get this. And then when the truancy law came up last night for second reading, there was quite a bit of opposition to it from the public, and there was some support for it, but also from within the council. And it was turned down on a 4-4 vote. You know, if you can't get a majority, it goes down. Well, Mr. Neely just was beside himself and was very upset about it because this was his campaign for the next council race. He got these laws through. Now, the interesting thing about these laws is the curfew law, there's a state curfew law. Same thing. It's not as restrictive as the local law, which puts a tremendous burden on parents who may be trying to do the right thing, but their kids are out of control. He had them being charged, fined, and everything like that. The state law does not do that. The state law recognizes the limitations that parents may have. Now, the law is that if a state law is less restrictive than the county or the city law or the local law that they're trying to enact over the same subject, the state law prevails. It takes precedent over the local law. And that's what would have happened here. So why he got so upset? The law was no good anyway. The state law controls. And there was one, and why go through this big rigmarole anyway? Can you play that tape? You'll see how upset Neely was for no reason.
As it took months to put together, but with just one vote, a truancy ordinance proposal failed. ABC 12's Kevin Holmes is live at Flint City Hall with the latest on what the city plans to do to combat truancy. Kevin?
Well, Michael, after hours of public comment, mostly in favor of this plan, the proposal failed with a split vote by City Council. And Vice President Sheldon Neely says the goal was to get more kids in Flint off the streets and back into the schools. And while truancy is an issue the public recognizes, not everyone agreed with this proposal. But since the proposal died, revisions are no longer an option. Instead, a daytime curfew amendment passed. This states children under the age of 16 are not allowed on the streets between 9 a.m. and 2 in the afternoon. But Sheldon Neely says the issue with this is there's nothing enforcing kids to be in school.
These kids need to be in school. Our school district is in trouble right now. They have a $5 million deficit. We have a 67% dropout rate. This municipality has a duty and responsibility to assist in every way possible to enhance the safety and education of our young people.
And there is already a nighttime curfew in place for children 16 and younger. This daytime curfew is expected to go into effect within the next 30 days. Reporting live at Flint City Hall, Kevin.
Now tell me how that would help the school if you send the police who don't have enough time to take care of robberies and burglaries and murders out to pick up kids they see wandering on the street. How is that going to help the schools? Arresting kids. Sending them up to the juvenile home, who won't accept them anyway, because there has been no final litigation on the matter. They won't accept them. So what are they going to do? This is nothing but a PR gimmick by Neely and the supporters. And I must say that the person who made the most sense and came across best on this issue was Carolyn Sims. She was very knowledgeable. She'd done her homework. You know, the school board, the school system wasn't even invited in, wasn't even asked to discuss this with him. He just did it himself. He wanted the publicity. He got it, and it's ridiculous. See you next week. In the meantime, I'll be at the White Horse.